Okay, Judge, we're live.
Okay, we have cause number 2019 0D02327, 2020 0D01920, and 2020 0D01979. These are three cases in which Ms. Falk is presently under indictment for. I believe she's been in jail for 435 days. And do we know what the total bond is at this time on those cases?
I see 5,000 on the 1920, and then I see 30,000 on the 1979, and 25,000 on the 2327.
Okay, so it's 5,000 on the, you said the 1920. And
Yes.
then how much on the others?
On the 1979, it's 30,000 or yeah. And 2327, it's 25,000.
Which would make a total bond of like $60,000, right?
That's correct, Your Honor.
And you are making a request on her behalf to have her released on a personal recognizance bond, right?
That's correct, Your Honor.
Because I think you said she does not have funds to make really any bond.
She does not, Your Honor.
Your Honor, I've been on PR bonds in the past and I've done well. I always checked in when I was supposed to.
Okay. And then let me look here. Let's see what's happened. The one case is an arson case, the 2327. The 1920 is a burglary of a building, and the 1979 case is an aggravated assault. Now, does the arson and the aggravated assault, do they involve the same complainant or different complainants?
Different.
Okay. Now, what kind of, one of them, the burglary was at a Family Dollar store. And the other one was lighting some stuff on some toilet paper or something on fire on the porch of the complainant's home.
It was my home, Your Honor, and I
Your
was
home?
lighting a fire to stay warm.
Ms. Falk, let the judge finish, and then I'll have a chance to ask you some questions.
Yes, sir.
Okay, and then we had the aggravated assault was on a female subject where they allegedly found the defendant on top of this other female, hitting her with their elbow, picked up a rock, and I don't know if she actually hit her. Miss Vergara, have you got any additional facts on those three cases that you think that we need to be aware of?
Your Honor, on this particular case, I do know she has a long history, Your Honor. And if I could just give me 1 second to check on the rest of it.
I give the kids, right? But I do so vital. Like an hour. So in an hour, your test case should turn right into a religion. So this test.
And I'm sorry, Your Honor, which case were you asking about?
Well, I want to go over the two that are most concerning to me are the ones where there's actual complainants, where there's violence alleged. One is the aggravated assault, the 1979, 2020, 1979, and the 2019, 2327. And I just want to know how much violence are we talking about there?
Yes, Your Honor. And so in the 1979, the aggravated assault with a deadly weapon, the investigative, so the supplement states that when the officers arrived, they found the victim and a witness on top of the defendant holding her down. The defendant was wearing white women's underwear over her black pants. Then the officers placed the defendant on handcuffs, and that's when they met with the victims and the witnesses. Meanwhile, they did have Rescue 9 and Pumper 9 arrive to assist with injuries. It looks like the defendant had struck one of the victims in the upper stomach area with her elbow, causing the victim pain as she walked by. And then she began to yell at the victim, "Stop touching me. You're not allowed to touch me, you bitch." Apparently, the victim only spoke Spanish, and so she understood most of what the defendant was saying, but not entirely all of it. We do have the manager of the store who observed the incident and did tell the defendant to please leave.
The manager punched me in my face for no reason, Your Honor. And then I got jumped by 5 people. When the police showed up, I was on the ground being attacked.
Ms. Fogg, we're not going to try the case today. She's just outlining some facts and some allegations.
That's me to hear lies.
I know, but I'm mostly interested in your liberty and hopefully getting you released. So let's focus on that.
That would be nice.
So then once they get at the checkout line, we have victim 2 is standing at the checkout line, as well as victim 1. And they see that the defendant is now outside gathering rocks and putting them on the concrete portion. And they continue to observe as the witness continued to observe the manager as the victim number 2 walked out of the store. Then he saw the defendant throwing rocks at victim number 2. It looks like victim number 2 thought the defendant was still yelling at the victim inside the store. And all victim number 2 said was that she appeared to act crazy. Victim number 2 said they had seen the offender being escorted out of the store by the manager. And when he left the store and walked across Cotton, he stated that the defendant began to yell at him for some unknown reason as this victim continued to walk. And then the defendant started throwing more rocks at him to the point he had to jump out of the way to avoid being struck by the rocks.
Okay. Now, what about the arson case?
Well, there's one more, Judge. There's one more victim in this case. It's victim number 3. And she was shielding her children. This victim was shielding children. And that's when the defendant threw the rock at the victim. And so in order to avoid the children from being hit, it actually hit her in the
I
arm.
hope you got the video from this day, Mr. Montez Jr., so I can prove my innocence. The police officer said there was store surveillance, and I hope you got that.
Well,
I can prove my innocence.
Ms. Fogg, let the judge finish the hearing.
Yes, Your Honor.
And then
We'll have our chance.
And then the allegations as far as the arson, Your Honor, are as follows. It looks like the victim was asleep in the bedroom when he heard banging in the front porch. When he went to the door and opened it, he saw the defendant crouched down, starting a fire at the base of his front door with a roll of toilet paper. The victim said that he started to stomp out the fire with his foot and with his foot. At that point, he said the defendant was not making any sense and was acting crazy. It looks like the defendant made her way into the apartment and began trashing the victim's apartment. And by trashing, they said throwing objects around the living room, as well as the kitchen area, throwing a mirror in the floor, some other items that were in the kitchen, table, etc.
My items, my home.
The victim then stated for the defendant to please leave the house, which the defendant refused to do. And then he heard the defendant yelling, "You want to burn? If you want to die, go ahead and stay in there." The victim went ahead and then opened the front door, saw the fire burning against the front door. I'm sorry. So once the defendant, once the victim had asked the defendant to leave, once there was trashing of the apartment and all of that, he managed to close the door and lock the front door. And that's when he called 911. And then that's when he smelled something burning. And that's when the defendant said, "You want to burn? If you want to die, go ahead and stay in there." And when he opened that front door, that's when there's burning newspaper. And so he stomps it off away again. And he noticed that the front porch area had been destroyed. The defendant was no longer in sight, but he could hear her. He thinks that the value of the front door was maybe $70 and the porch area about $100 to be fixed. And
My Lord. Are you serious?
Yes, it looks like then she was picked up, Your Honor. And that's when she went ahead and spit, and it landed on the officer's right side of the face.
Oh, my
And
Lord.
that's when she began kicking and yelling. I guess some of those kicks and ended up hitting the officer. And then, of course, there were some health concerns with the bodily fluids.
Oh, my Lord.
All right. And I suspect then your client, Mr. Montes, vehemently denies all of this and wants her day in court, a trial, right? Because you.
That's right, Your Honor.
All right. Well, these are serious allegations. Ms. Vergara, what they want a PR bond. What is your thoughts? What is your position?
Absolutely not, Judge. Just because it looks like the community is at risk, and it's not just the community as far as, I know some comments were made by the defendant as far as whether it was her house or not, but that victim still had to endure fire. And then once the officers are there trying to just sort things out, then they're getting spit on and kicked on. And then lastly, I do understand with the victims that were not involved in the initial verbal altercation at the store, they ended up getting rocks thrown at them when it doesn't appear that they had anything to do with the initial verbal altercation between victim number one and the defendant, Your Honor.
All right. Did you want to add anything, Mr. Montes?
Yes, Your Honor. Your Honor, this boils down to two things. Number one, Ms. Falk is not free because economically she cannot afford these excessive bonds. Your Honor, the critical thing for her is, as the court is well aware and has asked her in the past, what housing do you have? Where are you going to live in a stable environment? And the last factor is for her to have no further contact with law enforcement and no more criminal conduct that leads to her arrest. So, Your Honor, I'd like to turn it over to Ms. Falk to address those three things and tell you in her own words what her situation is.
All right. Go ahead, Ms. Falk. You
Your
can.
Honor, I've been dealing with the justice system since 2006. I pled out on charges I wasn't guilty of just to get out because this justice system is sad. They just want to prove They just want to deal with the cases as quickly as possible and make people sit here until they decide to plead out. This time, I don't want to do that. I've pled out in the past. I've been a victim of police harassment from the Northeast Police Department since 2006. They said I was arrested April 7th, 2019. I was not. I was arrested April 6th, 2019. And they held me in the Northeast Department. They were very rude. They made me pee on the floor. And then they took me to the hospital for no reason. And then they took my blood when I told them there's no reason for them to take my blood. They took my blood, they gave me something that knocked me out, took my blood, and ran all kinds of tests on me. I was arrested April 6th, not April 7th. They never read me my rights. They never show me the warrant for my arrest. They've made up warrants in the past.
Ms. Falk, I'm sorry to interrupt, but can you please address the three things that I raised? Number one, your financial ability to post bonds. Number two, where are you going to be housed so that you can have a stable environment? And number three, how can you assure this court that you will have no further contact with law enforcement due to questionable criminal conduct, which leads to your arrest? The judge wants to hear about those things.
Okay. I'm going to stay out of the Northeast. I would rather live somewhere on the east side or the west side. I have a little bit of money saved up, not much, but it's enough to where I can find temporary housing until I can find an apartment. I do not want to be in the Northeast anymore. I do get disability, so once I get out, it'll pick up again. And I would like to find a place probably somewhere in the east side.
Okay. All right. Well, thank you, Ms. Falk. I didn't, what was the criminal history of the defendant?
Yes, Your Honor. So we start back in, I'll go ahead and just go off her rap sheet, Your Honor. And back in 2008, she had an assault on a public servant for which she was convicted of a lesser charge of just a regular assault, and she was sentenced to 120 days in jail. Then she had a possession of marijuana as well in that 2008 case. She was sentenced to 14 days. She then had a criminal mischief again in 2008, for which she pleaded guilty and was sentenced to 30 days. There was another assault of a public servant on May 21st, 2008, for which I have no disposition available. Then we go to July of 2008, where she picked up another possession of marijuana, for which she did 5 days. We have an assault on a public servant on 8/29/2008, for which she again received another break, Your Honor, and pled to a lesser included of assault, and she received 120 days in jail. We have a criminal trespass in 2010, for which she received 5 days. It looks like as a result of that plea, she had a possession of marijuana, which was dismissed. We have a criminal trespass in 2012, another one, for which she received 5 days. An obstruction or retaliation, for which charges were dropped by the arresting agency. And in that case, if I'm not mistaken, it's El Paso Police Department. We have a criminal trespass of a habitation, shelter, or other infrastructure in 2012. And this is in September 20th of 2012, for which she received 100 days. We have another harassment of a public servant, for which charges were then dropped again by the El Paso Police Department. And this is 2012. There's a resisting arrest search.
I was innocent. That's why they dropped them, because they know I was innocent and I would prove it. How many did they drop when they said I harassed them? They were the ones harassing me, Your Honor.
Okay, well, I'm just trying to find out what your criminal history.
I'm sorry, Your Honor. This really upsets me.
There's a resisting arrest, search, or transportation in 2012 for which you received 100 days. There's an interfering with emergency request for assistance in 2012 for which you received 100 days. There's an assault causing serious bodily injury, which she was then pled to the lesser included of a Class A assault, and she was given 30 days. There is a assault causing bodily injury in 2016 for which she was given 30 days. There is another.
Some of the charges are made up. Some of those aren't mine. I think you're looking at someone else's record.
There is another harassment of a public servant, Your Honor, in 2016. No data is available on that. And then in 2016, on December 29, 2016, there's an attempt to take a weapon from an officer for which she was convicted of a lesser charge via 1244B and received 47 days in jail. There's a 2017 resisting arrest, search, or transportation for which she received 47 days in jail. There is a 2018 criminal mischief over $750 under $2,500 for which she received 20 days in jail. And then, of course, we have all of the now pending charges here, Your Honor, as well as in California. I have her as inflicting corporal or injury to spouse or a cohabitant. And
That was dropped because they proved I had nothing to do with that. Does it show it was dropped? Because it was. If you're gonna bring it up, you might as well say what happened. It was dropped.
And Your Honor, for that one, I do not have a disposition. I then do have a dismissal of an obstruction of a police officer.
All right, well, it's a fairly lengthy record, and there's a lot of alleged violent action. So I am not going to grant PR bond. The bonds will remain as they are. And we will set your case for jury trial as soon as we possibly can. As soon as we
So,
possibly
am
can.
I still gonna have court July 8th and July 12th?
No, we're not going to have trials yet. We have not gotten back to jury trials yet. We're about to get back to jury trials. As soon as we can get back to jury trials, we will. I have cases though where people have been in jail longer than you, and I've got to do theirs first. But as soon as you should get tried, hopefully before the end of the year.
Thank you, Your Honor.
Okay, thank you.
Your Honor, may I be excused?
Yes, you may.
Thank you, Judge.
All right. Now, let's proceed on to the next case, which was with, Mr. Macias. I saw him here earlier. What, did he leave then again?
No, he's here, Your Honor. And will we proceed on YouTube Live, Your Honor?
Yes, it's a plea.
Yes. Oh, okay, Your Honor.
Yes, we are. Okay, let us continue to proceed here. This is, hold on, let me get. All right. This is if we bring Mr. Isaac Rodriguez Jr. forward. All right. Where is he?
Good afternoon, Your Honor.
Good afternoon, Mr. Rodriguez.
Good afternoon.
So, Mr. Rodriguez, is your true and correct name Isaac Rodriguez Jr.?
Yes, sir.
And is your date of birth 8/18 of 1974?
Yes, sir.
And do you recognize your attorney, Mr. Francisco Macias?
Yes, sir.
And Mr. Macias, do you recognize your client, Mr. Rodriguez?
Yes, Your Honor, I do.
All right, now we have, I think we had I don't know how many charges, 3, 2019 0D03858, 2019 0D04512, and 2019 0D05513. I understand there's a plea agreement here. Would you like to state it on the record, Ms. Vergara?
Yes, Your Honor. The plea agreement is for 10 years TDC, and it is my understanding that they are for all the cases, Mr. Macias? To
That's
run-
correct.
Concurrent on all 3.
Yes, Your Honor.
Okay. And is that your understanding of the plea agreement, Mr. Macias?
Yes, Your Honor, it is.
And is it your understanding of the plea agreement, Mr. Rodriguez?
Yes, sir, it is.
With of course, the proviso that you get credit for all the time that you have actually served on
Yes,
these
sir.
cases. All right.
Yes, sir.
And with that, let's see, we have in front of us some documents, Mark States Exhibit 1, the guilty plea and waiver forms in these cases. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, sir.
Did you read them before you signed them?
Yes, sir.
Did you understand what you were reading and signing?
Yes, sir.
Did your attorney further explain to you the meaning of these documents?
Yes, sir, it did.
Do you have any question about their meaning?
No, sir.
So that there's never any question, let me briefly explain to you what they mean. Primarily 2 things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit these offenses or committed them as a party under the laws of the state of Texas. And secondly, that you understand you're giving up some valuable rights here today. The most important of those rights is your right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. You fully understand that.
Yes, sir.
Okay. Now, how do you plead then? Oh, let's see. So let's look at these charges. They are what degree felonies? They could be several. You have two cases in front of you, Ms. Vergara? Oh, you're on mute though.
I do, Your Honor, and I see 2 first degrees and 1 state jail felony. Mr. Macias, I know I'm stepping in, but would you mind telling me what we're doing with that state jail felony count?
Thought you were dismissing it.
In that case, Your Honor, then I guess we are dismissing it. So then we're only dealing with the 2, I'm sorry, we've got 1 first degree, the 4512 is a first degree.
Right.
And then the 5513 will be a second degree felony, Your Honor.
Right. And the first case I read to you, 2019 0D03858, has already been dismissed.
Yes, Your Honor. I'm not sure.
It was probably a superseding indictment into 2019 0D05513. So there's just the 2 indictments that are pending. And so they're first degree felonies. So the first degree felony, the punishment range is not less than 5 nor not more than 99 years or up to life imprisonment. And of course, with the defendant's criminal history, he could have been habitualized, correct? But the state is foregoing the habitualization
Correct, Your Honor.
paragraphs and proceeding under unindicted, unhabitualized counts. So it's 5 to 99 or life, or 2 to 20 to serve in the state penitentiary. You understand I'll sentence you somewhere within those general guidelines.
Yes, sir.
Now, how do you plead then to the 2 indictments, 2019 4512 and 2019 5513? Guilty or not guilty?
Guilty, Your Honor.
And
Guilty.
enter your pleas of guilty freely and voluntarily?
Yes, sir.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, sir.
Did anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
Yes, sir.
No, nobody promised you anything additional.
No, no, sir. No, sir.
It was just this particular agreement. Okay. You are a U.S. citizen,
Yes, sir.
and how old are you, sir?
46.
And how far did you go in school?
9th grade.
And you can read and write the English language?
Yes, sir.
Have you ever been under the care of a psychiatrist or psychologist for mental illness or mental disease issues?
No, sir.
Ever suffer any serious head injuries?
No, sir.
And you're telling me that you are competent mentally and you understand everything that's going on here today?
Yes, sir.
And then, Mr. Macias, you've gone over the facts and circumstances of these cases, the legal aspects of the cases, and had time to evaluate your client's mental status.
Yes, Your Honor, I have.
And based on all that, you're representing to me that you believe he is mentally competent to enter these pleas.
Yes, Your Honor, I do.
Then based on your representation, Mr. Macias, your representations, Mr. Rodriguez, and the court's observations of you in court, both here today and prior occasions, I find that you are competent to enter these pleas. The state may summarize the evidence.
Yes, Your Honor. Had the state gone to trial in cause number 2019-0D04512, the state would have proven beyond a reasonable doubt count number 2, which it does that on or about the 18th day of June 2019 in El Paso County, state of Texas, Isaac Rodriguez Jr., the defendant, did then and there knowingly possess with intent to deliver a controlled substance, in this case, heroin, in an amount including adulterants or dilutants of 4 grams or more, but less than 200 grams. And had the state gone to trial in cause number 2019-0D00513, 2019-0D05513, the state would have proven beyond a reasonable doubt that on or about the 6th day of July 2019 in El Paso County, state of Texas, Isaac Rodriguez Jr. did then and there knowingly possess with intent to deliver a controlled substance, in this case, heroin, having an aggregate weight including adulterants or dilutants of 1 gram or more, but less than 4 grams, Your Honor. And that would have been the summary of the evidence, Your Honor.
Objections, Your Honor.
No objection to the evidence. Okay, the court, of course, the court and the attorneys for the state and the defense have gone over all of the minute details of the facts of these cases and the defendant's criminal history at previous hearings. The court finds the evidence sufficient to find the defendant guilty and finds him guilty. I'm ready to proceed upon the issue of punishment. Now, when you get out, Mr. Rodriguez, what are your plans?
Stay in our trouble.
Okay, are you gonna go back? Who do you plan to live with when you get out?
My aunt's house.
Okay. Do you think you can get employment?
Yes, sir.
What type of work do you think you will be able to get?
Construction, Your Honor.
Is there anything else either side would like to add before I pronounce sentence then?
No, sir.
Nothing further from the state, Your Honor.
Part of the defense, Your Honor.
All right, well, I will follow the plea agreement. It'll be 10 years to serve on both cases. They will run concurrent. And I will give the defendant full credit for all the time that he's been in jail, which is a fairly significant number, over 700 days. So with that, good luck to you and thank you, Mr. Macias.
Thank you.
Yes, you may. Okay, now we have the next hearing is a little bit unusual because these are writs of habeas corpus filed by Mr. Mena. And I just don't have,
I don't see Mr. Mena on here anymore.
he might have had to leave for a few minutes.
Okay.
Let's find out what happened to him. He might have had another hearing that came up at the same time. Okay, we can go off live.